What's the difference between mediation and legal representation?
The difference between mediation and legal representation. Well, there's different types of legal representation, but we'll start with mediation. And actually with mediation you can be represented and your attorney can be with you at the mediation process or not. For the most part in family law, parties will use a neutral mediator, and then it'll just be the parties with that neutral mediator sitting down, going through what the different issues are and trying to work out an agreement on all. And if so, sometimes the mediator will draft up an agreement in the proper format that can be submitted to the court to become the stipulation in order. Other times the mediator will refer that out to someone to draft that, either an attorney or a paralegal or something of that nature. Other times it's more, tends to cost a little bit more, but if people want the support of having represented counsel there with them at the mediation, there's nothing wrong with each party having their own attorney, or perhaps even one party has an attorney and the mediator there. But the mediator doesn't represent either party. They're neutral. They just listen to the interests and concerns of each party and try to facilitate communication between the two, and hopefully they all arrive on the same page and work out something that's meaningful and workable and sustainable for everyone involved. And then it's committed to writing, submitted to the court, but the parties don't have to show up at court to argue over anything. And then legal representation, that there are different types. I typically distinguish between what I call cooperative or collaborative divorce. Cooperative it's actually what I tend to do in most of my cases, at least the ones where I'm not the mediator, and that's where I'm representing a party. I'm their attorney of record if anything's been filed. But the emphasis is on negotiated settlement. It's figuring out what issues there are, how can we resolve these as cost effectively as possible, as time efficiently as possible, and through authentic communication to both sides, not posturing, not taking positions, not holding back and hoping that more money can be made off of fighting over things and litigating. From the attorney's perspective, it's cutting all of that nonsense out of there, staying absolutely focused on what are the needs of my client and their spouse and the children, because it's only by being open to what everyone's needs are can you fashion an agreement that's going to make sense for everyone, and that's the only way that it can really be sustainable, and it has to be fair for everyone involved. And I'll often get questions, well, somebody's upset, and I don't want fair, I want what I'm entitled to. And well, in family law, it's the same thing. There's, you're dividing up time that you each have with your child. You're dividing up the limited resources, financial resources that you have, whether it's income or the property that you have. And the law is pretty clear on, property stuff must be divided up equally. So we can get into all kinds of different arguments over everything. I mean, there's a very thick family code that essentially lays out thousands and thousands of things you can argue about. But for the most part, the thing you're arguing over, the arguing costs you more than the underlying property item, and it's generally not worth the time and effort, at least for the parties. The attorneys stand to make a lot of money off of that, but I say save that money for your college education for your kids. Save that money for a family vacation, whatever, moving on with your life post-divorce, as opposed to your attorney's kids' college tuition or their new boat. So there's cooperative, which the emphasis is on negotiated settlement. And then there's collaborative divorce, which it has the same exact emphasis, but there's actually a written agreement that the parties and their attorneys enter into. Everyone signs a document that says, we agree not to litigate this case. And if we do litigate this case, we have to hire new attorneys and essentially kind of start from scratch. So the purpose of it is really to kind of create a disincentive to the attorneys to fight. Or to hold back from negotiating in hoping that they can make more money fighting later. It's to kind of all in settlement negotiating, which is a very effective way of going through and can be extremely supportive to everyone involved. Collaborative divorce doesn't only involve the two attorneys. It can involve, you know, working with a neutral person that helps with communication, a therapist, or a mediator type person that's involved in the situation. It can involve, you know, with a joint neutral forensic accountant if things need to be figured out as far as valuing a business or establishing what someone's income is from a, you know, something like a personal business or whatever, when finances are a little bit more complicated than just a wage earner kind of situation. So and all that stuff can be done in a cooperative divorce as well. It's just collaborative has that written agreement in place and the mandatory requirement that, you know, you hire a new attorney if things don't work out through the collaborative divorce process. And then there's conventional litigation, where you just start out with, you know, you meet with an attorney, the attorney says, okay, these are your rights, this is what we should file, we need to file a motion for this, a motion for that, a motion for that, and they prepare all those motions and they file everything with court, typically before they even pick up the phone and speak with your spouse, or if your spouse has represented their attorney. That is an extremely expensive way of going. It makes people very defensive, and it's where the ugly divorce, you know, that whole notion comes from. It's jumping right into fighting over everything, basically reacting out of anger or bitterness or upset that, you know, I'm going to really stick it to this person. The only person you're sticking it to is really you're sticking it to them, but you're also sticking it to yourself, and you're making things much worse for yourself. And like I've said, you know, time and again, the only people that benefit from most litigation is the actual attorneys, assuming they're getting paid in all of this. And a lot of attorneys, I'm not saying, you know, every profession has the bad seeds and all, but it just kind of, it's inherent in the conditioning, the training that we get in law school, the training that we get from, you know, older partners, senior partners when we first started practice. It's, okay, identify what issues there are and craft the arguments to argue and win on each of those issues. That's just the training, that's the wiring that happens when we go to law school and when we start practice. So it takes a long time to kind of, you know, deprogram and reprogram in more of a, you know, a settlement nature, and like resolving issues. How can we look at the situation and find a solution? I mean, you know, I think that's what attorneys really should be doing, as opposed to looking at how many issues they can spot and how many different arguments they can make. It's, okay, let's focus on what are the issues involved, how can we get this resolved so that it works for everybody.